This is about my fifth take. I'm trying to get this video punched out. Hopefully this one works. This is Liberal Dan. I guess they call him Liberal Dan because he's liberal. At any rate, he posted a video on Kyle Rittenhouse a few weeks ago, and the whole minor possession charge and the self-defense claims and everything, and he got it all fouled up. I called him on it. He now creates this reaction video to my video, and now I'm creating a reaction video to his reaction video. This is starting to look like two rappers going at it in their song lyrics. Hello out there. I am trying to get through.
With his powerful brainwaves cradled in the warmth of reasoning, it's time for Johnnie Walker Dread to straighten you out on a thing or two. Emanating all the way from exciting Las Vegas, Oklahoma, it's the Johnnie Walker Dread Show.
Welcome to Liberal Dan Radio here on YouTube. You can hear me live Wednesdays at 8 p.m. Central, either here on youtube.com/liberaldanradio or on Blog Talk Radio/liberaldan. And last week I did a podcast, and part of that podcast included a discussion of Kyle Rittenhouse and some of the novel concepts that Rittenhouse's defense have brought up as to why he should be considered to have been legally carrying the weapon that he was carrying. So, and this video happened to get a lot of people responding to it, including this YouTube user, Johnnie Walker Dread. And I'm just going to say, first and foremost, thank everybody for responding and commenting. You know, for the most part, there were some people who, maybe threw some insults around, and whatever, that happens from time to time. It's the internet. I'm used to it. I'm thankful that there was no, hey, you're fat, because that happens all the time. It's why I have my fat man rants that I post on my channel. But I do appreciate civil discussions with people with whom I disagree. Because sometimes, maybe I change their mind. Maybe they change my mind. Maybe they show that I have been either inaccurate or indelicate in how I've described an issue. Maybe I need to be a little more precise and a little less vague or general in discussing things. There was one such instance that took place here, and I do appreciate them pointing that out and showing where I could have been better in making my argument. There are other things where I still disagree with these individuals on this individual subject. But again, here, Johnnie Walker Dread. I do like the name, by the way, clever. So, thank you for responding. And he created this video in response to me. And so I feel we'll probably have a back and forth and response videos, which is cool. I like doing that. So without further ado, let's see what he has to say.
Well, we found another one. Liberal Dan, as he calls himself. He's going to weigh in on Kyle Rittenhouse.
Okay, so just want a little introduction for those of you who don't know me. I did not come up with the name Liberal Dan. I do call myself Liberal Dan. There is a conservative radio talk show host down here in New Orleans who was originally from up north. Up north, you might have known him as Ozone. His name is John Osterland, and I would say, hey, I'm Dan from wherever I was living at the time. And he'd be like, oh, it's Liberal Dan. And so it stuck. And then I would meet people unrelated, and it would somehow come out that I'm the guy that calls in under the name Liberal Dan. And they'd be like, oh my God, you're Liberal Dan. And the first couple times, it was just like, what? Why are you excited to meet me? I'm just a caller to local radio. But I guess it was exciting enough for them, to be able to, hear the, local celebrity, of what I was. I wouldn't call it that, but they were excited, so fine. I decided to go ahead and embrace the title and, got the domain name up and running, started the podcast. I had done some radio a little bit beforehand, but I've been doing this podcast for a while now. And so that's how I came to be Liberal Dan. Let's continue.
And I became Johnnie Walker Dread because that was my reggae DJ name. I DJ'd clubs and I did a lot of pirate radio back in the day of King Tubby and Prince Buster and, of course, the greatest band of all, the Dub Syndicate. One of the most sophisticated, crazy court cases to come down the pike in the last 50 years. And he's going to decide that, well, who cares about reading any of the background material? Who cares about following any of the news? Let me just read an article and then I'll weigh in on it.
Now, here's something that, he's assuming bad faith on my part, and it's coming from ignorance, because I could clearly say that he has not listened to my show before. He has not, heard me discuss this case before. I have other videos, which he later plays, that I've talked about the other video that I made about this. I've discussed Rittenhouse on my podcast. For him to just assume that I read this one article and decided to now weigh in on it is a false statement. Now, he may not have realized that it was a false statement. Maybe he just made a bad assumption. So I'm not going to say that he's lying, because too many people throw that word around incorrectly. But he is making that statement out of ignorance. I have looked into Wisconsin state laws, and we obviously disagree on what the law says too, which will be discussed later. But I've read many articles about what's going on with Rittenhouse, and I was willing at the very beginning when I started looking into this case to give him, Rittenhouse, the benefit of the doubt when it came to what was going on, because, here's this 17-year-old in a situation and really well over his head. And at the end of the day, I reached my conclusion not because of reading one article, but because of reading many articles and sources, etc., and listening, mind you, to people on both sides of the aisle as well to try and get a variety of opinions to help me form my own opinion. So let's continue.
Okay, first of all, let's talk a little bit about this Kyle was in over his head deal. No, the people who were in over their head, Anthony Huber, Gage Grosskreutz, and Jojo Rosenbaum, they were in over their head. And how do you say, and you might ask, well, what makes you think they were in over their head? Because they're either dead or wounded. Kyle walked away from the event. He was not in over his head. In fact, he handled himself very well. I've been around guns almost all my life. And I'm telling you, Kyle's handling of that weapon was extraordinary. He was not in over his head. No, chasing after a kid with an AR-15 rifle when all you have is a skateboard, that's the very definition of being in over your head. The other part about it is that he's saying, well, I've done lots of research. I've done lots of videos and articles. I've read lots of articles and stuff like that. Well, your understanding of what took place as far as the defense's argument with respect to the hunting law doesn't show it. All right, Liberal Dan, you tell us what happened that night in Kenosha.
Because under Wisconsin law, there are certain checkboxes that you need to check in order to justify a use of force, to defend yourself with deadly force, and to defend property with any force.
Now, notice, he kind of sounds like he's a reasonable person here. And listening to this, you might think, well, okay, he seems to know what he's talking about. No, he doesn't. When he gets into the details, you'll find out that he's got certain things missing.
And I clearly go over all of those instances where Kyle Rittenhouse, you can't, for example, you can't be committing a crime and then claim self-defense.
That's simply not true. He's misreading Wisconsin statutes. What the statutes say is that if you're committing a crime, the presumption that you are acting in self-defense disappears. So in other words, you can't be guaranteed to have been acting in self-defense if you're committing a crime. But that doesn't mean that you can't claim self-defense if you're committing a crime. You really think that jaywalking negates self-defense? Really? You really think that somebody could go over there, open fire on protesters, and the protesters, they cannot shoot back because they're breaking curfew? Who out there really thinks that? And as proof, on my own show, I disclosed the state of Wisconsin versus Coleman. He had...
Okay, before we get into Coleman, let's talk about the other two things that he said. Then it's one of the areas where I admit that perhaps I either indelicately or incompletely, or incorrectly stated what my view should have been on this. Clearly, jaywalking should not prohibit somebody from them protecting their own life. So if I'm crossing the street in violation of the traffic code and somebody attacks me and I fear for my life reasonably, I can use deadly force to protect myself. And that clearly that can happen. But it has nothing to do with what was going on, because one has nothing to do with the other. Me crossing the street illegally has nothing to do with the act that I'm now defending myself because somebody attacked me for it. Whereas...
Well, if they attacked you for it, then didn't your action have something to do with it?
If you go on the other side of the coin, and if somebody broke into a house, regardless of whether or not they're armed, if somebody broke into a house and then the owner was there and the owner started attacking them and the person who was breaking into the house decides to shoot in self-defense, no, you obviously cannot claim self-defense in that case. And I think we both would agree on that, because you put yourself in that situation, you put yourself in the dangerous situation, you created that, you provoked what happened to you, and as such, you're no longer able to act self-defense. Now, if you want to go...
Okay, the issue about breaking into a home is not that you put yourself in that situation. That's not the issue here. He's falling back on a misconception that if you place yourself in a dangerous situation, then you cannot defend yourself against any attacks. That's simply false. There's nothing in Wisconsin law that says that you lose your right to self-defense if you place yourself in a dangerous situation. Now, I went over this very thoroughly in another video. There are states where that is the case. They're called any provocation states. That means that any provocation that you do that creates a response where you have to defend yourself, you cannot claim self-defense. In other words, you have to be blameless. However, Wisconsin is not one of those states. Wisconsin's self-defense laws are actually quite loose. The issue about breaking into somebody's home is that you're placing the other person into a position where he feels that he may have to take action. But if you walk on private property and a person takes a shot at you, you can defend yourself, even though you placed yourself in that position.
Go back to let's make a ridiculous, and I'll freely admit that the situation is ridiculous. Let's say I decided to put on a rifle, strap a rifle to my back, and I was going to continuously keep jaywalking. And the reason that I had the rifle was in case my illegal jaywalking ended up causing somebody to, be coming at me in a vehicle, and I feared for my life because I might get run over by this vehicle that was coming my way, and I decided that the best way to protect myself was to shoot the driver. I could not then claim self-defense either.
Well, see here. Are you saying that protesters who stand out in the middle of the street, therefore angering people, causing them to react badly, they have no right to self-defense? Well, okay, but most liberals I know would never agree to that. If, however, you're jaywalking for the express purpose of causing somebody to react so that you can shoot them, you do lose your right to self-defense. Wisconsin law is really clear on that. There's only one small problem. There's zero evidence that Kyle did anything of the sort. Yes, he was carrying a rifle, but there's no evidence out there at all that he was walking around performing medical aid, defending property for the express purpose of shooting somebody. If you could come up with that evidence, then yeah, Kyle's going to lose. But no such evidence exists. Nothing on video, nothing in the social media, nothing.
Because I put myself in a situation and I'm not reasonable in thinking that that's the way to defend myself. That's not a reasonable thing to begin with. So, and I would argue that, if Rittenhouse is much closer to the breaking and entering side of things than he is to the jaywalking side of things.
Well, I don't know about that, especially if the judge comes back and says that it looks like Kyle's carrying of the gun was legal. Now what are you going to say? Breaking into somebody's home is a crime. What if the judge comes back and says that Kyle Rittenhouse's carrying of the rifle was legal? Are you going to then get on your video and say that Kyle is innocent? Because your argument is making that claim. Remember, Wisconsin law says that provocation involves unlawful conduct, not just something that provokes people.
If you're sitting there and you're counter protesting a Black Lives Matter or Antifa protest that protest was protesting police violence, and you were on the other side of that protesting or counter protesting, and somebody shot at you, then you would be able to use deadly force to shoot back because you're not necessarily doing anything to provoke. But that's not what he was there for. He is on video, and I've shared this in the comment sections below, admitting that he was there to defend a property.
That's right, defend property, not necessarily shoot somebody. He never said he was there to shoot people.
And give first aid or whatever. Two things that he's not trained to do. But
being trained to do has nothing to do with it.
He wasn't there to counter protest. He was there to defend property, which he's not legally entitled to do under the state of Wisconsin laws.
He's not been charged with that crime. Has he been charged with any crime related to the defense of property? No. So how can you declare him guilty of that crime in order to convict him?
So he was violating curfew. He was, according to the prosecution, carrying a weapon that he was not legally entitled to carry.
He's violating curfew, so that must be important. But you just got done saying that protesters should be able to defend themselves. But they're violating curfew. So is violation of curfew important or not?
And his just being there, and I've seen video where he was, they were up in each other's faces. Now, we don't have video of the entire night. So maybe there would be a video that would release that might shed some light on to what happened before each shooting that took place. However, I would argue that, again, Rittenhouse is much closer to the putting himself in a dangerous situation that he then is trying to use as an excuse to shoot people than he is to jaywalking.
All right, your argument is that he had intent. His intentions were to provoke people so that he could shoot them. What evidence do you have to support that claim? There is nothing. We have interviews of him all night. We watch him in action all night. They comb through his Twitter accounts and his Facebook accounts and Instagram accounts. They have found nothing. So by what right can you claim that that was his intention? Possibly it was, but usually you don't want to accuse people of something like that unless you have a good reason to. You have zero reason to.
Now let's continue. Let's hear about Coleman a little bit.
Firearm on him. He's a convicted felon. They even had a warrant out for his arrest. He'd already been convicted of a felony, and they had a felony warrant out for his arrest. The police did a no-knock bust into his house at night with a warrant. He opened fire on the police. Guess what? He claimed self-defense, and the Supreme Court of Wisconsin supported him.
Well, here's the difference between Coleman and Rittenhouse. Coleman wasn't out past curfew. Coleman wasn't walking around with a loaded rifle. He was in a house. He was in a personal dwelling, and the police did a no-knock warrant, as he said. Now, Coleman knew that there was a gun in the house, and fearing for his life because he didn't know who was coming through that door, he ran and got the gun.
Which is a crime. Cannot possess a firearm if you're a convicted felon. He committed a felony. Your argument earlier, don't forget, you said this. You said that you cannot defend yourself if you're committing a crime. My mentioning of Coleman was to show you a counterexample. And by the way, I did get it wrong about Coleman opening fire. However, there's plenty of examples of convicted felons opening fire on people and claiming self-defense successfully. I have 2 videos on it. According to your argument, they can't.
Then he came back and he was waiting at the door with the gun. So the police officers came through. He realized, oh crap, this is the police. This isn't just some criminal breaking into my house. He put the gun down. I don't believe he has it right that he shot the police. Maybe I don't remember reading that he shot the police. Maybe I don't know if he let one round out or not, but he's still living, so he probably didn't shoot. But that being said, once he realized what was going on, he put his gun down. It was like, nope, we're not doing this. So
if there had been robbers and he opened fire on them, he still would have been committing a felony. Felon in possession of a firearm. But I think most people would say it was self-defense in that case. Again, your original point was if you're committing a crime, you cannot claim self-defense. It's simply wrong. That was all that was about.
So clearly there's a huge difference between the Coleman case, where he was not out past curfew. He was not doing other illegal activities. He only grabbed the gun when he felt his life was in danger. Rittenhouse was walking around with the gun the entire night.
By the way, Wisconsin Department of Justice, I actually have a video on this. They said that the mere carrying of a rifle in public should not be construed as even disorderly conduct. Therefore, how can you claim that simply walking around with a rifle negates your claim to self-defense? Your argument is that if a person walks around with a rifle on their chest, they lose their right to self-defense. That's simply wrong. They're not committing a crime. Whether or not committing a crime negates your self-defense depends on how strong the nexus is between the crime that you're committing and the actual event.
And that's a very good point. And I would like to highlight this point. Yes, and this is probably where I either indelicately or inaccurately or whatever you want to put it, I'll apologize for not making this point as part of the argument. He adds a good point to it, so I will alter my argument in order to take into consideration this correct point. The nexus, or what makes the actions that were being done by the person claiming self-defense around the crime that they were committing and the self-defense, however tightly coupled they are, will then determine whether or not the actions negate the ability to declare self-defense or not. Clearly, jaywalking, there's no coupling going on, none whatsoever. So clearly, if you're jaywalking and then somebody attacks you in the middle of the street trying to kill you, you have the right to use deadly force to defend yourself. If you're in the breaking in the house and you're trying to rob some house and the owner of the house is there and starts going after you and starts trying to kill you for breaking into the house because they're in fear for their lives, justly and correctly, you then have no way to claim self-defense. Why? Because you're tightly coupled. Your presence there is very tightly coupled to the reason why the other people are going after you.
Okay, so let me ask you this. Suppose you stand out in the middle of a freeway, you shut down traffic because you're fighting for some sort of social justice issue. Okay? I'm not going to get into whether the social justice issue is right or wrong. That's not the issue. What you have are people blocking traffic, and obviously they're doing it to inconvenience the other people, right? That's why you block traffic, is to essentially anger the opponent. And you're claiming then that if somebody gets out of their truck with a gun and goes after one of the protester has no right to self-defense in that case. That's an interesting take, but that is your argument. Make no mistake about it. You just got done saying, what? Let's go back and play it again.
Self-defense. Why? Because, you're tightly coupled. Your presence there is very tightly coupled to the reason why the other people are going after you.
Your presence there is tightly coupled to the very reason why they're attacking you. Yeah, that sounds like a protester angering motorists by standing in front of them. Okay? So I'll let you work on that. You can chew up on it. Let's see how you do.
So I would argue that, again, Rittenhouse's actions are much, much closer to the breaking and entering. I'm saying he broke and entered. I'm just saying that his actions are much more tightly coupled than jaywalking.
Actually, no, they're not. And the reason why is, again, Wisconsin Department of Justice, the Attorney General of the state, stated that the mere carrying of a rifle out in public should not be construed as disorderly conduct. If it can't be construed as disorderly conduct, then how can you claim that it negates self-defense if somebody attacks them?
We'll just leave it at that. Let's go on.
Only a bonehead like this dude is going to go around thinking that if you're committing a crime of any sort, you cannot defend yourself. Nobody out there with any legal understanding believes that.
Okay, and so I thought, maybe I stated my opinion in a boneheaded way. And also I'll say, look, yes, I was wrong in saying that all crimes would negate self-defense. And that it is more correct to say that the more tightly coupled your crime is to the actions that cause you to claim to act in self-defense, the less likely you're going to be able to make a correct self-defense claim in court. Jaywalking, clearly not. But I would argue that in Rittenhouse's case, his crimes are more tightly coupled. So how I should have worded it, I guess, is his crimes that he committed that night would prevent him from declaring self-defense correctly.
Well, now let's take a look at this. What crimes are you talking about? Curfew violation? What about minor in possession? The judge might come back and say that was legal. Then what are you going to say? Are you going to be able to go in there and say, okay, well, guess what? I guess that Kyle is innocent. Hell no, you won't. You'll just create some other reason why he must be guilty. But you said his crimes should take away his self-defense right. Are you really claiming that curfew violation alone is going to do that? Because remember, the judge is still deciding on the minor possession deal, and I have a feeling the judge is going to weigh on the side of Kyle in that one, but we'll see.
If he was shown as the aggressor, he would have to then leave the area. And
you mean kind of like what he did?
No, and this is probably where we're going to have a disagreement on this issue. And I don't think I'm going to change his mind. He's probably not going to change my mind unless he were to provide additional video evidence of the night that I hadn't seen yet, showing him leaving the area and clearly giving up the fight, clearly stopping the fight.
Yeah, running away from somebody with your back to them is kind of giving up. I mean, in fact, I would suggest to you that that's the embodiment of giving up a fight, is when you run like hell away from your attacker. But not him. No.
Because that's, if you're the aggressor, and I would say that after the first shooting, that probably everybody around him was like, this guy's an aggressor. He just shot someone.
But what about the first shooting? You notice he kind of glossed over that one. What about that one?
So that's probably what the people were thinking when they were chasing him down, trying to prevent him from shooting anybody else.
Their motives are irrelevant. I go over that very thoroughly in this video and a lot of others too.
Now, that he's going to argue that his running away in and of itself is enough to say, I give up, I surrender, or I give up, I am no longer fighting you. But you can, just because you move to a different place on the map, it doesn't
move to another place on the map. That's what he's describing fleeing. When you run like hell away from somebody, that's not fleeing to him. Oh, that's moving to another location on the map. Are you kidding me? Could you come up with a bigger euphemism to support your argument than that? I mean, okay, I get it. The Marine Corps said something like that in Korea, right? We're really not retreating. We're actually just turning and attacking in the other direction, whatever. But here, Kyle is running from his attacker. Literally, it's on video. And he's yelling, friendly, friendly too, but I guess that doesn't matter.
Doesn't mean you've surrendered or you've stopped fighting or you've done whatever it is you need to do to declare yourself eligible to now defend yourself. It could just mean you're putting yourself into a better position from which to shoot people again.
Oh, it could mean, oh, really? Do you have any evidence to support that? I mean, no matter what Kyle did, you could always claim that he was only doing it as a feint, a ruse.
You know, getting a better position isn't retreating. Getting a better position isn't giving up the fight, isn't clearly, you know, maybe if he would have had his hands up and would have audibly said, look, I don't want to shoot anybody. I was shooting this guy in self-defense. I felt my life was in danger. Please don't.
Oh, Christ, are you going to ask him to send out a Western telegram? You don't have to sit there and explain verbally everything you're thinking. You just have to run. You have to make it clear to your attacker that you're not fighting anymore. That's what notice is. Notice is not a written notice or a verbal notice. It could be anything that you do to show your attacker that you're no longer fighting. And guess what? Running with your back to the person is pretty much a given in that situation. I think everybody, most normal people, would agree that if you're fighting and that person starts running away from you, he's probably giving up. After all, you don't have to chase him.
Come after me. That's the only reason why I shot him. If he would have said that, then perhaps, and then if the people would have started to continue to attack or chase or try and hurt him, maybe at that point, his continued firing of shots would be deemed by the prosecution to be justified.
So, in other words, maybe. In other words, probably not. In other words, if he put up his hands and he had a white flag and he announced to everybody, I'm giving up the fight, maybe that would be enough, which means we would just come up with another reason to paint him guilty. They want a conviction. They want a conviction badly. Nothing Kyle could have done there would have convinced these people that he was giving up. Because no matter what he did, they could always paint it as a clever ruse for him to take up a position where he could start shooting people like a sniper, even though nothing he did that night indicated he had any intentions of doing something like that. No matter what he did, it could always be interpreted as a feint in their minds. So there is no such thing as self-defense to these people. No such thing.
But there's no video evidence of him doing this and saying, look, until I think at the very end when he was approaching the cop cars, after his final shots, he then raises his hands once he sees the cops. But there's no situation, and at that point when his hands are raised, I would say that's the point that he gave up.
Yeah, because they're not chasing him any further. They're not chasing him at that time. They're not trying to kill him. That's what allows him to basically walk with his hands up. If he had done that earlier, they would have brained him. He did what you're supposed to do. Run like hell, create distance. And by the way, you can't run with your hands up while carrying an AR-15 and a single point sling in front of you. That rifle will flop all over the place. It's really difficult. He did it the way he's supposed to. He was holding on the rifle so that he could maintain balance while he was running. You can't do this. Try it sometime.
That's the point that he stopped fighting. Not any time before. Had he done this,
That's right. Running from somebody is not stopping fighting, according to him. He's still fighting. When Kyle is running from Joseph Rosenbaum, he's still fighting. And when he's running away from the mob chasing him, he's fighting. That's how these people think. That's why there's no self-defense. No matter what you do, you're guilty.
He raised his hands up in the air and said, I am not wanting to fight you. I was just defending myself from this person who I felt was a danger to my life. And had he done that,
he'd be dead because the mob would have taken over him, taken his rifle from him, stomped a mud hole in him, maybe even shot him. You have way too much faith in the peacefulness of a mob. You should watch a few more videos of these riots, get an idea of what they can do. Kyle knew. He did exactly what I would have told my son to do. If my son called and said, hey, Dad, there's an angry mob chasing after me, I would tell him, run like hell, run to the police. Guess where Kyle was running? To the police. The police are in front of him. He's running towards them. And the attackers saw the police up there. They saw them. They tried to stop him from getting to the police. You kind of ignore that fact.
then we wouldn't be having this discussion at least about the other two individuals. But he didn't do that. He didn't make it clear. And in my reading of the Wisconsin law, you have to make it clear.
No, you have to give adequate notice. That's not the same as proving beyond reasonable doubt.
Onus is on you to make it clear. You can't be vague about it.
What's vague about running from somebody? Is that vague? Gee, I wonder if he's still fighting me or if he's quit. Well, he's running away from me. I think that's pretty clear. He's quit. Because otherwise, it's a very strange way to fight.
You have to clearly say, I'm no longer fighting. Stop. I'm not fighting. My hands off my weapon. I'm not fighting you. I'm not going to shoot at you. We need to stop this. We need to take a break. I'm not doing anything threatening to you.
Does yelling friendly count?
Stop. He didn't do that. So it wasn't clear enough that he did. And maybe he was ignorant of his requirements of doing that because of his age, inexperience, lack of training, etc. But ignorance of the law is an excuse to break the law. So let's continue.
He couldn't have done it. He couldn't hold up his hands and say, turn around to Joseph Rosenbaum and say, hey man, I'm not fighting you anymore. Joseph would have killed him. Yeah, he's 5'4". I mean, JoJo's a small guy, but he can fight. He's been in a lot of fights. Kyle has. And if you want to see Kyle fight, go watch the fight with the girl. He's no fighter. He had to run. That was his best thing to do, is he ran. And guess what? I don't know if you know this or not, but let's see, a liberal Dan, if you can get this through your noggin. Joseph Rosenbaum did not have to chase him. Therefore, Joseph Rosenbaum is the aggressor. No doubt about it.
Show that he's left the area to establish himself, kind of like in football, when somebody goes out of bounds and they have to reestablish themselves as a valid receiver. You have to, if you were an aggressor, then you have to basically run away for a second.
Let me think here. If you're the aggressor, and no, by the way, nobody's claimed that he's the aggressor yet, but let's just assume that he was, he has to leave the area. He has to run. That's kind of what he did.
And that way, I'm no longer, I'm giving up. I'm not doing anything to you. I'm giving up. And it has to be significant.
Yeah, significant, like running away from the person. That's kind of significant.
Kind of significant is not clear. Let me read specifically from the Wisconsin state law.
Okay, so he's going to use the word clear in this. Let's wait for the word clear here.
The privilege lost by provocation may be regained if the actor in good faith withdraws from the fight and gives adequate notice thereof to his or her assailant. Adequate notice thereof is the key terms.
Yeah, adequate notice. And for most people, when the person runs away from you, that's adequate notice that they've given up the fight. Who in the hell disagrees with that besides him? Really? Seriously?
The notice has to be adequate. And I would argue, if I was the prosecution, that simply repositioning oneself while running is not adequate notice.
Repositioning oneself while running. Oh, geez. Another euphemism. I'm repositioning myself. No, he's fleeing. It's called fleeing. You can see it on video. He's running away from his attacker.
Adequate notice would be, I give up. Let's stop. Hands up in the air. We are not, I don't want to continue doing this. We need to stop. Period. He never did that. He never raised his hands until he was by the police cars. So to me, at that point, he gave adequate notice that he was no longer wanting to fight. But at that point, the police were right there as well. Up until that point, I don't believe he gave adequate notice.
Well, wait a minute. He didn't say anything like, I'm giving up when he was walking to the police. So it wasn't adequate notice at all. You said earlier that he had to claim out loud, I'm giving myself up. I'm no longer fighting. He didn't do that. So all of a sudden, why is that adequate notice? And I'll tell you the reason why. Kyle didn't shoot anybody after that, and therefore he doesn't have to try to pin a murder charge on Kyle for anything like that. Therefore, the definition of adequate notice changes.
Have to convince the people. If anything, there are people who saw him shoot the guy in the head. If anybody, it's possible that those people were considering that they were committing acts of self-defense or defense of other people.
Yeah, another person who's not a lawyer, he doesn't get it. This common myth amongst a lot of people is that if I am claiming self-defense against you, that negates your claim of self-defense. It's actually quite possible for Kyle and his attackers to be all acting in self-defense at that time. And there's plenty of examples where this can happen, and the Kyle Rittenhouse shooting is one of them. And the reason why this can happen is because if you read the way that the statutes are written, it's all about what the person who's being attacked believes. And therefore...
And let's stop there, because that is a very important point.
No, this is called deflection. The issue here is about whether two people can claim self-defense against each other. That's the issue here, and now you're going to pick on some minor issue, which I have already covered in my other videos.
Because he says it depends on what the person believes, but that is not the words of the law. The words of the law is that the person has to reasonably believe it. What a person believes is irrelevant. What a person reasonably believes. Somebody has to reasonably believe that something is a threat to their lives. If the belief is not reasonable, it is not valid either. So this is an important point that Johnnie Walker Dredd needs to consider, is that just simply believing it to be true isn't enough. That belief has to be reasonable.
It's not an important point, it's a deflection. I've already gone over this in one of my videos. I spent a lot of time talking about reasonable belief and whether a juror can place themselves into the situation of Kyle or not, and what is the standard for reasonable belief. I know all this crap. That's not the point. This was not the issue. The issue here was whether two people can have valid self-defense claims against each other. So if you want to put the word reasonable in front of belief and all throughout my entire argument, go ahead. Your claim, you clearly implied in your argument that if one person has a valid self-defense claim against another, that negates the other person's self-defense claim. It's wrong, and sorry, but you're wrong, and now you're trying to deflect with this real minor issue. Or if you're being attacked and you believe that the interference of the other person is unlawful and a deadly threat, you have the right to self-defense.
Again, it's not just belief, it's reasonably.
Yeah, we get it.
Believe. If your belief that you have the ability to defend yourself in this point, and that belief is not reasonable, you're not entitled to that act of self-defense. Then that act that you're claiming of self-defense is criminal.
However, the person attacking you, he might believe that you pose a serious threat to bodily harm to him, and therefore he can claim self-defense.
Well, he can claim self-defense all they want, but if it's not a reasonable belief, again, he doesn't have the right to take that action.
Okay, another one. When I say that a person can claim self-defense, it's understood I'm talking about a valid claim of self-defense. I shouldn't have to qualify that every time. My argument is very clear here. If person A has a valid self-defense claim against person B can still have a valid self-defense claim against person A, contrary to what you implied in your earlier statement. That's what this was all about.
So that again, it's a very important point. The belief must be reasonable. Furthermore, whether or not your belief is reasonable that the person is going to kill you, there's also the other factors that come into play, is who is the provocateur. So both parties might very well claim self-defense, but if there's a clear person who's provoking and a clear person who's being provoked, then only the provoked person would be able to claim that, even if both people are reasonable in their belief.
In other words, yeah, it may be that when you have two people claiming self-defense, only one of them might have a valid self-defense claim. Sure, we get it, but that wasn't the point. You implied that if person A has a valid self-defense claim against person B, that the person B cannot have a valid self-defense claim against person A. You're wrong, okay? Own up to it.
That the other person is a threat to their lives. Because, again, both people can claim self-defense. Everybody can claim self-defense if they want to. But in order for it to be a valid claim of self-defense, the belief that their life is in danger has to be reasonable, and they need not be the provocateur. Period. But none of them he fit. There's no boxes there that he checked. So he is not allowed, under Wisconsin state law, to defend that property with any amount of force, let alone deadly force.
Well, okay, a few things. There's no boxes to be checked here. That's not how Wisconsin self-defense laws are written.
Yeah, there's no literal boxes that have to be checked. Yeah.
Okay.
I mean, it's just a metaphor. So in order for you to claim self-defense, one of these things have to be true. So if you made a checklist of all of the possible ways that you could claim self-defense, as long as you check one of them off correctly, you have an adequate, correct claim of self-defense. So if he doesn't check any of those boxes, proverbially, he can't claim self-defense legally. His claim of self-defense will be denied in a court of law.
Well, that'd be true for pretty much any law, but okay. But more importantly, it doesn't make any difference whether Kyle said he was out there to defend property that night, which he was doing at one time. He had left the property. He was no longer protecting it. Whatever laws there are about defending a property in self-defense are moot because he wasn't defending property at the time. He had walked off the property and was walking down Sheridan Street when he was ambushed by Joseph Rosenbaum. The fact that he was guarding property earlier in the evening, completely irrelevant.
I disagree. It goes to his intent. His intent of being there was to defend property and give first aid. He is not trained to do either of those things.
Okay, show me in the Wisconsin statutes anything about training.
But that's what his intent was, to be there. That was his intent.
But he left the property. It doesn't matter why he was there that night. He had left the property. And therefore, there is no nexus between defense of property and self-defense in this case. There's no connection. He could have been ambushed guarding property that night.
So to ignore his intent on being there is to willingly decouple something from his actions that should not be decoupled. It should he was violating curfew. He was carrying a illegal weapon, according to the prosecution, and he was trying to protect property that under Wisconsin law he has no right to do. He has no right to defend the property because, again, there's a certain group of people who can defend a particular property with force.
Has he been charged with any crimes related to that? If he hasn't been charged with the crime, then how can you use that crime against him?
So not even deadly force, just force, because you're not allowed to use deadly force to simply protect property in the state of Wisconsin. You're only allowed to use deadly force if you're protecting somebody's life while protecting somebody's property. But
yeah, if Jojo Rosenbaum had stepped foot on the property and Kyle shot him, you might have a point. He didn't. You have no point. This is a stupid argument. Not even Binger is making this argument. Just think how bad your argument is when not even Binger is making it.
But only the owner of the property, a member of the immediate family or household of the property, or an agent or a manager who works at the property, or somebody who's an employee of the property is able to defend the property with force, not deadly force. You can't even threaten deadly force unless it escalates to beyond damage of property or theft of property.
If the owner of the property had walked off the property and was walking down Sheridan Avenue and Joseph Rosenbaum attacked him, there would be no difference in the case at all. It'd be the same.
So, and it's important to notice that he is, again, it's another thing that he's trying to do that he doesn't have the right to do. A lot of people, and I'm not saying that this user, that Johnnie Walker Dread, is applauding Rittenhouse for being there defending people's property. But there are the people who are, he was just there defending property. Well, he had no right to do so, and it shows his intents were again, extra legal. When he was saying that he was there defending this property, that they were not just there defending this property, but all property that was there, that they felt that it was their responsibility, him and the other people that were with him, to defend property in an armed way from the people who were there protesting the police action.
Yeah, again, if he had shot somebody who got onto the property, you might have a point. He didn't.
And they don't have the right to do so. They don't have the right to use force to defend property.
Okay, then charge him with a crime then. It's a misdemeanor at best. Charge him with the crime.
No right to do so. So it extends to what his intent was that night. And that's why I think it's relevant. Because it seems that they've now changed their minds. According to NBC News, hunting laws allowed Kyle Rittenhouse to carry a weapon during fatal shootings in Wisconsin, lawyers say.
Oh, for Christ's sake, why don't you get your news from another source or actually watch the actual proceedings so that you can hear the actual attorneys talking?
And here's the thing, again, another time where he's assuming bad faith on my part, as if this one source wasn't the only one that I looked at before.
You shouldn't have even looked at that source. It's garbage.
Or talking about this on my podcast. I happen to read from one source, but that doesn't mean that I only looked at that one source. So that's a big difference. And you're making an assumption based off of your existing prejudices about, I guess, how you feel about liberal folks. And fine, whatever.
Well, did you cite these other sources in your video? Did you talk about them? Did you bring information from these sources, from these other sources, and discuss it? No.
There are liberal people who are in the media who I've ridiculed and criticized from time to time because I felt that they were not acting in a way that was honest or sharing the facts properly. You know, I'm not beyond criticizing my own side of the aisle as well. But so perhaps because of those other people, you have you feel justified in maybe assuming that I would only look at this one before making my arguments. But I looked at other ones. So let's go on.
The attorneys for Kyle Rittenhouse did not change their argument. What changed was the fact that NBC News decided to screw up the headline, and they roped people like you right into it.
Prosecutor Thomas Binger dismissed the defense argument, said Rittenhouse attorney should tell a jury he was hunting on the streets in Kenosha. Now, if that doesn't show that they're admitting intent, who was he hunting? He was hunting people.
No, that was Binger's argument. By the way, it's Binger, not Binger. I followed this thing very closely. I have paid a lot of attention to the Kyle Rittenhouse shootings. Okay.
And if you wait for a second, you'll see that I acknowledged that I somewhat misspoke my argument, and then I corrected my saying so. But he doesn't then acknowledge the fact that I went back and said, yes, this was the prosecutor saying it. So it's a little bit of dishonesty here on the part of Johnnie Walker Dredd. So
Binger got it all screwed up too.
That's actually the prosecutor saying that. That's right. So the prosecutor said that. So the defense is basically saying he was hunting. Yeah.
Oh, the defense is not saying that.
Lawsuit, that he was there under no good.
According to the lawsuit.
Yeah, I said lawsuit wrong. Get over it. Okay. Yeah, I said lawsuit instead of trial. You know, yeah, I misspoke one thing. I'm sure you've never misspoken anything in your life before. But here you go. Here's the thing. The defense is making the argument that hunting statutes allow him to hold that gun, despite the fact that otherwise he wouldn't be able to hold a gun because he's under 18. So if there are exceptions in hunting, then therefore you have to be hunting to use those exceptions to the general rule of you're under 18, you can't hold this weapon.
Your problem is that the law that the defense is resting on is not a hunting exception. They're just calling that in the media. It's not a hunting exception. It's quite the opposite. But you never bothered to read the statutes. If you had, you'd realize that the NBC News article got it all fouled up.
So again, if the judge rules that the law is written in an improper way and creates this legal vagary that needs to be cleaned up in the law, fine. That's beyond my pay grade. But at the end of the day, if the rule is there, if the law is there for hunting purposes, then you should only be bringing it up as an exception to the general rule of if you're under 18, you can't hold this gun if you're hunting. So was he hunting? No, then it shouldn't apply.
This is a terrible legal argument he's got here. Okay. Calling something a hunting exception doesn't imply what the actual law says. And in fact, the law is not a hunting exception at all. And by the law, I'm talking about the substatute that the defense is claiming exonerates Kyle of the whole minor in possession charge. Yeah, it's called a hunting exception by some people rather lazily. It is not a hunting exception at all. In fact, what does the law say? Essentially, that one is required to have a hunting certificate. Okay? That doesn't sound like an exception. That sounds like a criteria. So calling this thing a hunting exception and then using the name of it and using that term to try to figure out what the law says is pretty bad. That's really sloppy law. Binger would be proud of that one. And by the way, I don't think Binger figured this thing out either.
Period. Schroeder said that the state statutes were unclear and he wanted to review the laws and revisit this matter later.
Okay, so if Judge Bruce Schroeder, a judge, is coming in and saying, hey, it's not real clear here, I'm going to need more time to examine this, then you might have went back and thought, I must have it wrong about what the defense is claiming. Because if the defense is claiming that Kyle was out hunting that night, the judge would have thrown the defense's motion out the window right then and there.
Well, the defense is saying that the hunting laws, the hunting exceptions apply. How else could the hunting exception apply unless he was hunting?
No, that's not what the defense is saying. You got it wrong. Why don't you go back and read the statutes? I have a video on this. I have 3 videos on this where I go over these statutes in great detail. I even go through Binger's arguments about. I probably have 5 videos actually on this hunting exception, as you like to call it. That is not the defense's argument.
Or, as I've said already before in this video, that maybe the law is in fact poorly written, and the judge will determine that if the law is poorly written, creating a loophole that, or a vagary in the law that would then say, okay, maybe. But to me, it's the defense grasping at straws, trying to say that hunting laws allow for him to possess the weapon that night, when the only thing that hunting laws should do is make an exception for people while they are hunting. And, I tend to be a person who thinks that the intent of the law is important. And a conservative will often say, well, the intent of the law is not important. We should be textualists when we're looking at the law, when we're looking at the Constitution. But then they'll cite the Federalist Papers, which just explain the intent of the Constitution. So I don't get conservatives on that point. They want to be textualists, from your commentators on YouTube all the way up to your Rand Pauls and Ted Cruz's and everybody else who's conservative, who wants to insist that judges be strict textualists, and then they go cite what the founding fathers said in the Federalist Papers. That's using intent to interpret the law as written. So you can't have it both ways.
I have no idea where he's going with this. I don't even see why this is a conservative versus liberal deal here. The defense's argument is not that the law is clumsily written, although they'll take it, because then the judge still has to rule in their favor. The defense is really making a statement that the law is really clear here. In their mind, the law clearly states that Kyle is in compliance with the substatute because he doesn't have to have a hunting certificate, because he's not hunting. That's their claim. The prosecution is claiming that they're not in compliance with the substatute because he doesn't have a hunting certificate, regardless of whether he was hunting or not. That's the debate. Both sides think that the law clearly speaks their language. The judge is confused on the matter, and the defense is coming in and saying, well, if you're confused, you still have to rule in our favor. It's called the rule of lenity. You can look it up if you like. But I cannot understand how you could still screw this up. I called you out on this in my previous video. Why didn't that spur you to crack open the minor in possession rules and read the arguments? If you want, I'll post a link to my video. You can listen to me go through exactly what the defense is claiming and exactly what the prosecution is claiming. There's no mystery here. The only mystery is how Binger ever got a law degree.
I do think, sure, let's look at the Federalist Papers to see what our founding fathers meant when they wrote the Constitution. Just like we should look at the intent of the law and use, I hate to say common sense, because there's no such thing anymore. But if a law is written to make exceptions for people who hunt, then those exceptions should only count when you're hunting.
Yes, exactly. And that's the defense's argument. You still haven't figured it out. That's the defense claiming that. They're claiming that this statute only applies to people who are hunting. And therefore, Kyle is not in non-compliance with the statute because it doesn't apply to him.
It shouldn't be that difficult. If that's the argument that they're going to use, they're screwed. I think Rittenhouse is going to go up a creek and be sent up the river, sent down river, sent buried under the prison, whatever you want to say. That's Rittenhouse. Anyway, let's go ahead and take the first commercial break. We'll come back, take your calls as well.
All right. Notice how he smiles when he starts talking about Kyle going up the creek and getting put under the prison. You see what I'm talking about?
My smiling there is at the absurdity that one would use a exception to the law written for hunters to justify carrying a weapon on the streets of Kenosha that night. It's
Well, okay, but you got it all fouled up.
the ridiculousness of the argument that is making me smile at that point. I'm not happy that anybody has to go to jail. I wish Rittenhouse wouldn't have been there in the first place, that he would have just cleaned graffiti earlier in the day and just left it at that.
I wish he hadn't been attacked by a bunch of idiots, but okay.
No business being there. He was not trained to defend people, defend property, to give first aid like an EMS or whatever. He had no business being there. And I think there were a lot of people who failed Rittenhouse that night.
He had no business being there. He's relying on another fallacy about self-defense. Self-defense says nothing about a person's business being there. Not in Wisconsin. In some states, called any provocation states, that could be true, but not Wisconsin.
Right. But he still should be old enough to understand that doing certain things are wrong, and that his actions, in my opinion, that night were wrong. And we will see at the end of this case whether or not a jury agrees that his actions rise to the level of criminality and as such send him to jail. So I'm not joyful that anybody will go to jail. I'm just amused at the absurdity that is sometimes brought up by criminal defense lawyers. And look, don't get me wrong. We need criminal defense attorneys in this country. You know, they play a vital role in protecting our system of justice and making sure that our system of justice works. It's just that some defense attorneys come up with some doozy arguments that make everybody just want to shake their head. And to me, any argument that says an exception written for hunters should apply in a non-hunting situation, you're reaching for straws at this point. So,
okay, I'm going to go back and say it again. You got upset because I said that you didn't do your research. You didn't do your research. You don't know what the fuck you're talking about. And that's your problem. You want me to come up with a video where I can explain these substatutes to you? Do you? Do I have to do that? I already did, actually. I have 5 videos on this. But at some point, you should have went back and thought to yourself, you know, maybe I should go and look into this a little deeper. Because Johnnie Walker Dredd created a video where he claimed that I didn't know what the hell I was talking about with respect to these substatutes. Maybe I should read them, but you didn't. You have no idea what that substatute even says. I could ask you right now, tell me what that substatute says about hunting, and you wouldn't be able to tell me squat. You still haven't read it. Enough of this, man. I'm sick of it. Now, you want to do another response video? Hey, fine. You go ahead, but I want you to read the fucking statutes first, then do your video. Because I just can't handle the ignorance anymore. Sick of it. Like my videos, subscribe to my channel.